A few days ago, the Times newspaper, oh, it was in the Sunday Times, in fact. The Sunday Times newspaper dropped this article about the Lucy Letby case, suggesting that families united to debunk Lucy Letby's innocence claims. The first thing that I would say about this article is that it's entirely based on the document that I responded to in my previous video. There's no new information here whatsoever. All that's happened is that Sean Linton, the health editor, has pulled a few quotes out of it and then responded and then reproduced them. So he says here, Lucy Letby is accused of trying to control the narrative and use her own victimhood as a way of deflecting attention away from her actions. And he makes it clear here that it's according to legal submissions. So it's made pretty clear in the first paragraph, but the implication of the headline is that somehow the families have had a meeting and come up with some new information, which simply isn't true. So there are numerous claims made in this. I've already responded to many of them in my previous video, but I wanted to get into the specific information regarding the infants. So in this first video on that topic, I'm going to deal with child I. Now, I've already dealt with the second part of this assertion regarding the tube not being in place, but I'll just read this paragraph from the Times article. In the case of child I, who died in October 2015, Letby's experts argued a bacterial infection caused thick secretions to block an endotracheal tube, interfering with ventilation. The family's lawyers said testing indicated the child had never developed the infection. So that's what we're going to be assessing in this video, the legitimacy of that assertion and whether or not testing had indeed eliminated the possibility that the child had developed this infection. Please note that they haven't even named the infection. So I assume that's because it's not named in the actual document. So Sean Linton didn't know what it was, so he couldn't write it down. I assume that's the reason. I don't know. But I will be discussing the infection in the next section, and we're going to go through all of the evidence that is quite extensive, which points to this statement being very poorly founded indeed. So we're going to begin by just looking at the bacterium itself, which is Stenotrophomonas maltophilia. I've been practicing that. I'll no doubt pronounce it incorrectly at some point during this video, but it's mentioned during the press conference as being significant in this case of child I. So I've just pulled up, this is on the National Library of Medicine website, one of the less known drug-resistant bacteria that can cause challenging infections. So I think the fact that it's less known could be significant immediately. And there's some general introduction there. I think this is more interesting. Stenotrophomonas maltophilia is a gram-negative bacillus, I think that's pronounced, initially called Bacterium buceri when it was first identified in 1943 from a specimen of human pleural fluid. You don't need to know all of this, but this is just an introduction. It was later classified as Pseudomonas maltophilia in 1961, then reassigned to the Gamma proteobacteria class as Anthramonas maltophilia in 1983, and eventually classified as Stenotrophomonas in, well, that's obviously a typographic error, 1990 something. The name has Greek roots meaning the narrow feeder that loves malt. The whole genome sequence of representative isolate K2179A genome sequence was published in 2008. This is considered a newly emerging pathogen of concern that is being isolated more frequently. It is also recognised as one of the underestimated important multi-drug resistant organisms in hospitals by the World Health Organization. It was ranked as the 9th most important one per British microbiologists, one of the challenging pathogens in the infectious disease community and studies. It is widely known as an opportunistic organism associated with high morbidity and mortality rates among immunocompromised patients. Stenotrophomonas maltophilia, a non-fermenting gram-negative rod, is the third most common after Pseudomonas aeruginosa and Acinetobacter, and similar to Acromonobacter, Xylos oxidans, and Burkholderia sepsia. This document will be over soon, I promise. It is the only species among the 17 of the Stenotrophomonas genus that infects man. Now, I'm going to stop at this point, but I'll read this paragraph as well. Risk factors for this infection include chronic respiratory diseases, especially cystic fibrosis, hematologic malignancy, chemotherapy-induced neutropenia, organ transplant patients, immunodeficiency virus, HIV, infection, hemodialysis patients, and neonates. We got there eventually. Also, hospital settings, prolonged intensive care unit stays, mechanical ventilation, tracheostomies, central venous catheters, several traumatic injuries, significant burns, mucositis or mucosal barrier damaging factors, and the use of broad spectrum antibiotic courses were shown to increase the risk of infection. These empiric broad spectrum antimicrobials usually do not cover this particular pathogen, especially carbapenems, although no specific predominance was identified with them over other microbials. The risk from antibiotic exposure varies directly with both the duration and number of antimicrobials used. So what is significant about this whole section of etiology, which is immensely complicated for any non-medic such as myself and probably people watching this? Firstly, Pseudomonas aeruginosa is mentioned here, and there's a relationship between Pseudomonas and this bacterium, which I'm going to go into later. What I think is particularly significant here is if we look at the risk factors. Obviously, neonates are particularly mentioned, but a lot of these issues, such as respiratory diseases, were seen on the unit with a lot of these infants. Hospital settings such as prolonged stays in intensive care units were seen as being significant. Venous catheters were seen as being significant. These are all increasing the risk of infection from this bacterium, and we know that they were all present on the unit. These were across multiple infants in this case, but in the case of child eye in particular, we know that all these things were issues, and we saw there were several examples of catheters being incorrectly inserted, for example. So that's all interesting in and of itself. Now, I'm not qualified really to analyse this in any meaningful way. I can just read it out just about and recognise aspects of the etiology of this condition that are relevant to this case and are relevant to the situation that counts as Chester. I just wanted to establish what was the bacterium that was cited by the experts, and we're going to go into some more information about this that I'm going to try to break down and make as simple as possible as this video continues. So the claim made in this article was that testing indicated the child had never developed the infection. Okay. So firstly, if you go to the Thirlwall inquiry and look up Stenotrophomonas, you get no results. Now that could partly be because the search facility on this website is terrible. So I did a Google search, and you do get one result. You do get one result if you search for using the site address, but it's just for the closing submission document, and the only references to the condition are those made by the panel. So it wasn't mentioned once during the Thirlwall inquiry. Then you move on to Cheshire Standard, not mentioned at all, ever, in the Cheshire Standard. Then you move on to Tattle Life, which is another big source of information, never mentioned once in Tattle Life. Then we'll have a look at, specifically Child H and Child I. This is the page on Tattle for Child H and Child I. And we're going to be looking at the actual transcripts in a second as well, just in case people who still believe that Lucy Letby is guilty are like getting ready to criticise me for using online resources. We're going to be looking at the court transcript shortly, so you don't need to sharpen your pencils just yet. Let me make sure I'm spelling this correctly. Steno. No references to it whatsoever. So let's look at infection here, which I can't type. infection. So that's child H. This is child I. They're saying the mother is very annoyed at a nurse who appeared to have a cold. The mother said she did not want her baby to get an infection. It's interesting when we look at the court transcripts, you'll see some other interesting information regarding to infections, but I mean, this is quite pertinent. There were readings consistent with infection, but child I was on antibiotics, a lumbar puncture and phototherapy were commenced. Feeds were commenced using expressed breast milk, and child I continued to be very stable in spite of having an infection. So we know this infant had an infection. In fact, there are numerous markers of infection. It does say here the CRP infection marker was low, but the white blood cell count was elevated. I think that's particularly significant. Blood culture tests were awaited for signs of an infection. Some discussion about infection could be an underlying cause of some symptoms in this infant. Dr. Bowen says this was a baby with an infection who was deteriorating. Dr. Bowen says these weren't sudden catastrophic collapses, but moderate deterioration of a baby which had an infection. Dr. Bowen said the incident was not knowable, the child had an infection. Now, I'm not citing these examples to show that the infant had an infection. That's undeniable. The infant definitely had infections. I'm just showing that there's no reference to this condition in any of these sources or with regard to the word infection. We're going to return to look at something else in a second. So then I looked up the term Letby Stenotrophomonas online. All the references, look, it's February, all the way down. And then it goes into like 2022, which is clearly nothing to do with the court case. It's an unrelated article. And then you could continue. This is actually quite interesting. This is an article about the condition in neonates, but we're going to be looking at some medical documents later on. So this is February 2025, unrelated. This is the item that the document from Thirlwall we've already flagged up. This was 6 days ago. You get the general idea. It wasn't mentioned during the court case. Let's just remind ourselves of what was said. The family's lawyers said testing indicate the child had never developed the infection. So we're going to go through the court transcripts now, and then we're going to return to more reporting just to establish something further. So these are the court transcripts of the cross-examination of Dr. Evans for child I. You'll have to take my word for it that the condition doesn't appear in this transcript, but I've searched for the condition within the transcript and it doesn't appear. So there's some comments here about infection is always a consideration when a baby collapses, so she was given some new antibiotics. The conclusion I drew was that something had happened out of the blue. If she'd been sickening for an infection or one of the complications that one gets with premature babies, I would have expected her to need a little bit of oxygen support. So that's Dr. Evans dismissing the idea that she had a significant infection. It's these kind of, I'd say, quite vague statements he makes that are not really, when you read the descriptions from the panel, they're just forensic surgical descriptions of the conditions and precisely why those conditions exist. Here you just see him saying, well, if she'd had an infection, I would have expected this to have happened over the previous hours. It's all very general. There's nothing there to indicate. And also, I want to point out, the assertion from the family states that testing had eliminated the possibility this infection exists. So if that was the case, Dr. Evans could just say, well, we had tests were done and there was no infection. Whereas he's saying, if there'd been an infection, I would have expected to see this. So that immediately very strongly implies that the testing hasn't been done. But anyway, or that he didn't know about it. He should know about it. He spent 5 years preparing for the court case. So let's move on to the next reference, the term infection. just taking that opinion and looking at alternatives so far as infections or anything like that were concerned, could you see in the records any suggestion of a sort of benign explanation which could account for what happened to baby I? There was no evidence of it. Secondly, a response to resuscitation is not one would expect if she had an infection. Again, it's just these general statements. If she'd been resuscitated and responded this way, that's not what would have happened if she had an infection. Infections tend, this is Dr. Evans again, he's going to go on now, babies tend to recover over a number of days. So he's dismissing the idea this infant has an infection. Dr. Evans is not saying, oh, testing was done so we specifically know that there was no infection. Quite the opposite. So let's move on to the next bit. There's one more reference to infection. He just says here there was no collapsed lung, there was no pneumothorax, there was no infection. It doesn't give any specific background to this. I think there are a few more references actually. Yeah, there are a few more references after this. But yeah, there's no specifics about. But I'll come back to this in a second. Do you agree there were periods when she had infection or suspected infection and received treatment for that? Yes, she did. And they're going on to talk about necrotizing enterocolitis as well. Again, this is, Ben Myers is laying into Dr. Evans here, rightly so, and he's saying, no, it is my looking for an explanation as to what caused this baby to collapse on 13th of October when there was no evidence of infection. So it's just a repetition, really. And then lastly, it's again him going, babies don't do that. If, for instance, on the 13th, the event was due to infection, I would not have expected this and this wouldn't have happened. She wouldn't have recovered as quickly. It's just very non-specific, non-clinical observations that I'm quite certain if you get a neonatologist to look at these explanations and look at these statements, they will say it's flippant, it's poorly founded, etc. However, the point is, there's no indication of testing here. Now, the next thing we're going to search for is the word test. Now, in this transcript, this is the only reference to the word test. Ashley Hudson's evidence was very moving because nurses and doctors know that one would call a normal cry sounds like because babies will cry if they're hungry, they'll cry if you take blood tests from them because it hurts. I suppose it would be better if that sentence actually made sense, but as you can see, it's a very non-specific reference to blood tests. All these other references up here are towards generally the intestinal. You can see here the word greatest, gastrointestinal, intestine, etc. The word test only appears on this one occasion. Now, I realise this is complex. It's complicated for me too, so I'm trying to go through it slowly. So I'm going back to look at the record on Tattle to look for testing here. Now, it's interesting, a lot of the references to testing are of no relevance to the issue, but this reference here, when the parents arrived, they were informed child I did not have necrotizing enterocolitis, that's an abbreviation of that, and she improved. The mother was not happy that no test was taken to categorically rule out necrotizing enterocolitis, as that could have informed her future care. So I think here, it can't even really be said definitively that this child did not have this very serious condition, necrotizing enterocolitis. It was inserted in court that child I didn't have necrotizing enterocolitis, but I don't think we can say it's been satisfactorily established. As far as I can see from what I've got available to me and what can reasonably be located online, this was never ruled out with testing. And then there are some more kind of references to testing, and here in the cross-examination of Dr. David Harkness, he mentions that blood culture tests were awaited for signs of an infection. I can't find any indication that those blood culture tests were ever returned. It says here further tests were sought to check for NEC and to monitor child I's bowels. I don't think those tests were ever returned. I don't think they were ever made, in fact. It says they were sought, but I don't think they ever occurred. But the important thing here is that if there was any blood testing done, which is doubtful, it was very rudimentary testing. Now, I'm going to show you now why that's important. So now I'm going to ask ChatGPT this question: can blood cultures recognise Stenotrophomonas maltophilia? That's assuming the blood culture tests were done. I assume that the lawyers and the Times article, the Times article's done absolutely no research, they don't really know what they're talking about, but I'm assuming the lawyers from the Thirlwall families group are claiming that these blood tests have been done. Can blood cultures recognise Stenotrophomonas maltophilia? Yes, blood cultures can detect Stenotrophomonas maltophilia, but additional testing is usually required for definitive identification. Let me read that to you again. Additional testing is usually required for definitive identification. So some explanation here of maltophilia, and then it goes on to say blood culture growth. If maltophilia is present in the bloodstream, it can grow in aerobic blood culture bottles. And then there's a variety of ways that follow-up testing is done. Now I'm going to expand on that further. But that gives a very clear indication. There's a lot of things that we need to know about testing in this case, because it relates to things that we know about other infants in the case. But this initially demonstrates clearly that blood cultures alone cannot confirm the presence or otherwise of this bacterium. So I'm going to ask ChatGPT a follow-up question now. What follow-up tests are required after blood culture tests to confirm the presence of Stenotrophomonas maltophilia? After a blood culture detects Stenotrophomonas maltophilia, follow-up tests are essential to confirm the presence of the organism and guide appropriate treatment. The tests include, I'm not going to read all of this because I don't know the difference between an oxidase test, a catalase test, and a motility test, for example, let alone what an API 20NE is. But I'll just go over the titles. Gram staining and microscopy, subculture on selective media, biochemical identification, MALDI-TOF mass spectrometry. We're going to come back to that in a second. Molecular testing, antimicrobial susceptibility testing, additional tests for clinical relevance. Now, I'm not a medic and I don't know which of these tests, how many of these tests, whether it requires all of these tests, but it's quite clear that there needs to be follow-up testing. Now, it's firstly, I believe, not established that there was definitely testing done at all, but I can say with absolute confidence that follow-up testing wasn't done. And I can say that not only because there's no evidence for that, but also because of what we know about the hospital with regards to other aspects of the testing. And I'm going to begin that investigation by just mentioning mass spectrometry and discussing that a little bit. So I've asked ChatGPT a follow-up question here related to mass spectrometry, which I spelled incorrectly. Is mass spectrometry required to confirm the application of exogenous insulin? Yes, mass spectrometry is often required to confirm the use of exogenous insulin. I should just mention that exogenous insulin means externally injected rather than naturally occurring internally. Particularly in doping investigations, forensic toxicology, and clinical diagnostics. While immunoassays can detect insulin levels, they cannot distinguish between endogenous, naturally produced, and exogenous injected insulin. So that's critically important because we know in this court case they relied on immunoassays, and we know that they didn't use mass spectrometry. That's very significant because insulin experts have roundly criticised this, and indeed it's been criticised in relation to other court cases for other people that are in prison for similar offences, including Colin Norris, who has his appeal coming up in May. So in the insulin cases, the insulin data is absolutely central to the entire case. Indeed, it's the only item of evidence. Lucy Letby isn't even on duty for one of the hypothetical circumstances in which she's supposed to have poisoned an infant, child F. It is literally the only item of evidence, and we know that rather sloppy evidence has been put forward. I'm going to go over this in more depth as well. But even just on this basis alone, we know they used immunoassays, which ChatGPT is saying here, I'm just using it as an illustration, that they just simply cannot distinguish between the two. But this is well known anyway. So they had to use mass spectrometry there for the one item of evidence that is relevant to those cases, and they didn't. So what are the chances that they've done the follow-up tests in relation to child eye, even if they've even done the blood test in the first place, because they didn't bother doing the test for necrotizing enterocolitis? There's numerous explanations here for why you use mass spectrometry instead of immunoassays. So now I've asked ChatGPT another relevant question, which is the link between Stenotrophomonas maltophilia and Pseudomonas aeruginosa. Stenotrophomonas maltophilia and Pseudomonas aeruginosa are both opportunistic, multi-drug resistant, gram-negative bacteria that are frequently associated with hospital-acquired infections. They share several similarities and interactions, including the following. Now, the reason I'm asking this question, the reason that I'm highlighting this information is I'm sure quite a few people watching this video already know that Pseudomonas has been confirmed as present on the neonatal unit at the Countess of Chester. So I'm not going to go through all of this information, but there's environmental and clinical overlap, shared resistance mechanisms. I mean, this is extremely complex. Co-infections and synergistic effects. I just want to lastly go over this competition in coexistence and treatment challenges section. While both bacteria compete for nutrients and space, they can also coexist. Some studies indicate that aeruginosa produces antimicrobial compounds that suppress maltophilia, while maltophilia can modify the local environment, making it more hospitable for aeruginosa. I will just mention one thing. Both bacteria are found in moist environments such as hospital water systems, ventilators, catheters, and biofilms. This is why Pseudomonas had infected the taps and the sink unit at the Countess of Chester. It was explained to me by a microbiologist that this biofilm aspect is particularly significant, and it's why sink type environments can be very vulnerable to Pseudomonas if they're not kept surgically clean. I'll just move on to treatment challenges as well. The presence of both pathogens complicates treatment because they respond differently to antibiotics. Maltophilia is often resistant to carbapenems, which are sometimes used against aeruginosa, and aeruginosa resistant to trimethoprim sulfamethoxazole. I think that's correct. Often used against maltophilia. I really didn't think I'd ever find myself saying all these words, but I'm doing my best. So as you can see, there's problems with resistance, but we know this, the bacteria often antibiotic resistant, there's a lot of problems. But the reason, as I say, I'm raising this is it's confirmed that Pseudomonas was present on the neonatal ward, which is obviously very significant, but I'm going to demonstrate why that is so significant with regard to what has been stated in relation to child eye. So the next thing to discuss is the evidence for Pseudomonas aeruginosa on the unit. This is quite commonly known by now. The Daily Telegraph article here by Sarah Napton has been fantastic in covering this case. The neonatal unit where Lucy Letby works suffered an outbreak of bacteria lethal to babies, a leaked risk report shows, and bacterium Pseudomonas aeruginosa had colonised taps in the nursery of the neonatal unit, including intensive care. I won't read this whole article because I think many people are aware of this already. It's been covered in The Guardian as well, and I think probably other newspapers. It's pretty commonly known fact about the hospital. David Livermore, Professor of Medical Microbiology at the University of East Anglia, said Pseudomonas aeruginosa is an environmental organism that likes moisture. It can be lethal in newborns, especially premature ones who lack a properly developed immune system. From mid-2015 to mid-2016, there were around 17 infant deaths at the Countess of Chester unit. We are asked to believe that this comprised two superimposed clusters, one of 7 murders by Lucy Letby, and one where, to quote the Crown Prosecution Expert, they died for the usual problems why small babies die: hemorrhage, infection, congenital problems. It is simpler to believe that we are looking at a single spike of fatal infections in a chaotic unit. As I say, it's important to emphasise that this only came to light after the trial. I mean, I can't find any reference to it during the trial, but I'll return to that subject in a second. Firstly, Pseudomonas is mentioned in a few documents from Thirlwall. You can see it here in this risk register. So it's not as if it wasn't known on the unit. It's there in the risk register in September 2016. It's mentioned here in the opening statement of the senior management team. These included Pseudomonas risk. And there's another reference to it here in another document from Thirlwall. These are all documents from the Thirlwall inquiry. So it's been submitted to the Thirlwall inquiry. There are other references. I just wanted to show you some of the main ones. And then the most it was ever mentioned in the public inquiry itself, though, was this occasion, where you can see there's a few short references to it here, and then that's it. It just disappears because they just never followed it up at all. So it never, despite the significance of this, despite the unsanitary conditions on the unit, despite the fact Pseudomonas was circulating, it's known to be this dangerous pathogen. This was not acknowledged by the Thirlwall inquiry, despite the fact it's in the Thirlwall inquiry documents, and it did not form part of the court case whatsoever. I haven't been able to find any reference to it, despite searching quite diligently. And I think part of the reason for that is that in the reviews that were done of the hospital, for some reason in the final reports, it was never mentioned. Now, I've done some research on this, and I've got some original material on this, which unfortunately I can't discuss at the moment for legal reasons, but it'll probably be in my book when it's released. But there are some serious question marks about this, let's just say that. So it's really important to understand that, because not only does this show you that there's another pathogen circulating on this unit, but it also shows the kind of lax legal process in relation to this, in that we've just had an official inquiry that lasted months and they barely acknowledged it, and the court case didn't acknowledge it at all. So the idea, so the original assertion about this other infection that has been cited by the expert panel, what they're saying is that the testing had been done and that had been ruled out completely, and this has been included as part of the court case. We're going to dig into that further still and see if that statement stands up. But here's another infection that we know 100% was on the unit. Was that part of the court case? Absolutely not. Was there any indication that they tested for that? No, because they didn't need to give indication they tested for it, because they knew it was on the unit. There's no doubt that it's on the unit. That's not contested. It's in documents from Thirlwall. It's even mentioned in the Thirlwall inquiry, that although they glossed over it. It's been in the national press, in several newspapers. Did this form part of the court case? Was there any mention of testing of this? Absolutely not. So when Dr. Dowie Evans was interviewed by John Sweeney in his excellent podcast series that you should check out if you haven't heard before, I'm sure many people listening have heard it, and Ed Ablesmith I should mention as well. But John Sweeney conducted the interview, and this is kind of emblematic, I would say, of the attitude of Evans towards the hospital and details that appeared in court. Because he simply had an exchange with Sweeney regarding sepsis, pneumonia, and the sewage problem on the unit. Again, the sewage problem has been very well documented. It's almost infamous by now that the defence only called one defence witness, and that was a plumber. And they discussed the sewage issue for a while. So I'll just read out this exchange. I'm not going to try and do a Welsh accent, by the way. I'm just going to read it out. So Sweeney said, pneumonia is a subset of sepsis. I mean, another scenario is not that there is a murderer. This is a badly run unit, and also there's a sewage problem, right? Evans says, as far as the sewage problem is concerned, I don't know when this occurred. Now, already that's a very strange thing to say, because he was the primary prosecution witness. He claims just to be an expert witness who was impartial. I think that's pretty dubious, seems he worked for the police. But anyway, he was certainly a witness in court for a considerable period of time. So it's very difficult to understand how he wouldn't know about the sewage problem. I mean, possibly nodded off in court. Maybe he wasn't in court that day. But you would think he would know about a principal aspect of the trial that's been widely reported since the trial was over. But he claims he just doesn't know anything about it. Or maybe he'd make the legalistic argument that I don't know when this occurred. That's not saying I literally don't know about it, but it's a very strange statement. It's the kind of slippery thing that these kind of people say, but it is a very odd thing to say. So anyway, Sweeney says they didn't know about the raw sewage in the unit. They didn't know about the killer bacteria. But then Evan says, and none of us knew about that as far as I know. Again, it's just the kind of thing, and none of us knew about that as far as I know. What does that even mean? I mean, it doesn't even mean anything, but he's sort of claiming it's like a disclaimer, isn't it? It's saying, I didn't realise that there was sewage on the unit. How did you not realise it? You should have known about it, firstly, and secondly, you should definitely have known about it by the time someone's in court talking about it. Then Sweeney says, interesting though, isn't it? Isn't it noteworthy? I mean, we asked one former neonatal doctor, paediatrician, neonatal experience, how many units he'd worked on where there had been raw sewage, and he's already interrupting, saying it shouldn't, never, never. I mean, was it in your unit? Good God, no. Good God, no. What would you do if there was a raw sewage leak? What would you have done? It would have been sorted. We would have closed the unit down. We'd have demanded that the management sort out the problem together, sort the plumbing out, would not admit any babies until it was dealt with. This is possibly the most reasonable thing that Dr. Evans has ever said. It's, of course, completely true, undeniable. I mean, you shouldn't have raw sewage in any form of, you wouldn't have it in normal residential. If you had raw sewage in your house, it would be a major problem immediately, let alone on a neonatal unit or even in any form, in any aspect of the hospital, but particularly an aspect of the hospital that's dealing with, incredibly vulnerable infants. Obviously, it's a complete disaster. And yet this was still, at least this was mentioned in court, but the attitude of this is emblematic of the attitude of Dr. Evans in court. And it's so, because of what we see here, this very blithe attitude towards, well, I didn't know anything about any sewage. He similarly glosses over or doesn't mention or doesn't make reference to or dismisses the significance of, the likes of sepsis. We don't hear about Pseudomonas in the court case. We don't hear about numerous clinical problems. We don't hear about. He constantly claims, oh yeah, but I took the state of the hospital into account. I took the state of the sanitary conditions into account. But this provides the lie to that statement essentially, and it is very significant when we're looking at this subject as a whole. Now, the next thing to mention is that there's a very strong relationship between sewage and Pseudomonas. So I'm not going to discuss this in great depth because it's not contested at all, and anyone can find this out with a very simple Google search. It really isn't difficult. But I'm just going to go through some of the scientific papers to just demonstrate that this is the case. So this is one. Whole genome sequencing identifies highly related Pseudomonas aeruginosa strains in multiple wash basin U-bends at several locations in one hospital. Evidence for tracking of potential pathogens via wastewater pipes. This paper is antibiotic-resistant Pseudomonas aeruginosa from hospital wastewater and superficial water. Are they genetically related? This paper, Pseudomonas aeruginosa, spread of antimicrobial resistance in hospital effluent and surface water. Occurrence of Pseudomonas aeruginosa in wastewater and its behaviour under biological treatment. Diversity antibiotic resistance profiles of Pseudomonas from a hospital wastewater treatment plant. Antibiotic resistance of bacteria in raw and biologically treated sewage and in groundwater below leaking sewers. This references Pseudomonas among other pathogens. Antimicrobial resistance of Pseudomonas isolated from wastewater and wastewater impacted marine coastal zone. Changes in wastewater treatment performance in the microbial community during the bioaugmentation of a denitrifying Pseudomonas strain in the low carbon nitrogen ratio sequencing batch reactor. So I'm not going to go into any details regarding any of those things. Of course, they're very deep scientific papers, but they just really establish the link between Pseudomonas and sewage. So given that there was sewage on the unit, it doesn't take long before Pseudomonas can be resident. That's why they had a Pseudomonas outbreak. This is considered an extremely dangerous pathogen. It's fatal very quickly for vulnerable infants, for neonates, for the kind of children that are on the unit. And as John Sweeney just made this point, and I made this point in the previous video, there were 11 deaths on this unit that were accounted for by Dr. Evans by giving the usual explanations that you would expect of they're very vulnerable infants, they've got weaknesses in it by their very nature, they're vulnerable. Unfortunately, some of them can pass away with the best care, and then there are congenital reasons, and then on top of that, there are all these problems in the hospital. We know there's other problems that are beyond the scope of this video to do with staffing, but we know about the sanitary conditions, and that's very well established. This is just another example of how bad it was. The thing is that this was entirely discounted during the court case. It really was barely mentioned at all, except the defence brought in the plumber to talk about the sewage. But they really didn't scratch the surface of this topic. And when it came to infection, Dr. Evans just denied it all the time. Throughout the interview, in fact, with John Sweeney, you see him constantly saying sepsis isn't relevant, Pseudomonas isn't relevant. And he did this, and he also makes reference to pneumonia. And he did this throughout the court case. He just constantly just said, there's no infections, all these children were perfectly fine, they're recovering, they're okay, then they just collapsed for no reason. The only reason is Lucy Letby attacked them. And that's a critical thing, because we're going to go on to look at what was said about infection in the court case and whether, you know, the criticism regarding testing is valid. So I just wanted to mention this briefly as well. This is the link between Pseudomonas and sepsis. So again, this is very well established, but I just wanted to show this briefly on ChatGPT. Pseudomonas aeruginosa is a type of bacteria that can cause a variety of infections, and it is one of the common pathogens associated with sepsis, a life-threatening condition that occurs when the body has an extreme response to an infection. And then there's a lot of information about the extent to which these two things are linked. And it's pretty much undeniable that there's a link between the two of them. I'll just read the conclusion, really. I think rather than going through all that information that can be you can easily establish this yourself, and it's not something that can be contested anyway. So I'll just read the conclusion. The link between Pseudomonas aeruginosa and sepsis lies in the bacterium's ability to cause infections, especially in immunocompromised individuals, which can progress to bacteremia, maybe that's pronounced bacteremia, I think, and then sepsis. Why can't we just go straight to sepsis? The bacterial toxins and other virulence factors contribute to the severe inflammatory response seen in sepsis, making Pseudomonas a critical pathogen in this life-threatening condition. So, I mean, that's as plain as a nose on your face. But I just wanted to go over that briefly because I think it's extremely important to establish that. So, essentially, the takeaway from that is as soon as you've got Pseudomonas on the unit, you then have the risk of sepsis. And therefore, it's not surprising that there was endemic sepsis on the unit, with nine of the 17 infants involved in the court case having either confirmed or suspected sepsis. One of the other interesting aspects of this is that I interviewed an expert in microbiology, and he told me that considering the presence of Pseudomonas on the ward, he said he wouldn't be surprised if there were other pathogens circulating at the Countess of Chester as well. This was before we found out about this Stenotrophomonas maltophilia infection that is the subject of this video. And then within literally a couple of weeks of speaking with him, this new information emerged, indicating that there was this other infection and this other pathogen. So I found that very interesting because he essentially predicted that would be the case before it happened. So we can see from various articles, I've just picked out a few here, that Dr. Evans repeatedly ruled out conditions such as sepsis, particularly sepsis. I cannot see any conceivable justification for this because there is such strong evidence. Even the Thirlwall inquiry, there are dozens of documents pointing to sepsis being present on the unit. We know now that it was definitely present. It was endemic, realistically. And yet, we see a BBC article here where Dr. Evans ruled out other conditions such as sepsis. There's a Daily Telegraph article here from September 2024, in which Sarah Napton talks about Dr. Evans ruling out infection, sepsis, or congenital problems. So it essentially means he ruled out infection in every case that was involved in the court case, including sepsis. Whereas here, when there's a recent report from the London Evening Standard, when they're talking about child D, or baby 4 as they've described it, and they immediately suggest the cause of death was systemic sepsis, pneumonia and disseminated intravascular coagulation. Now, they don't downplay the significance of sepsis and pneumonia, because there's just overwhelming evidence that this child was suffering from infection. And I'm glad that there's this article, because we're going to briefly just go over some of the information that indicates that child D was suffering. So I'm just going to go over this very briefly, but in the case of child D, the coroner gave the cause of death as pneumonia with acute lung injury. But in court, Dr. Evans observed that a child exhibiting window of near recovery on 2 occasions, followed by another collapse, was not consistent with the fatal evolution of antenatal pneumonia. Now, there's some discussion of this throughout the remainder of the cross-examination of Dr. Evans and the case of child D in general. But it's notable that essentially everyone else that has looked at these notes, apart from Dr. Bohin, of course, has come to the conclusion that pneumonia was significant, but he just dismissed it completely. There is so much evidence that this child was suffering with acute pneumonia that it's frankly unbelievable that he came to this conclusion that literally no one else agrees with. And that's just indicative of his general attitude towards infection. And as he was so prominently involved in the court case, and other experts, as we discussed in previous videos, were really very minor parts of the court case, the attitude of the court, or what the jury has heard regarding infection generally, has been an attitude of dismissal towards it, when in actual fact, that shouldn't have been the case. So he's dismissed every incident of sepsis, he's dismissed pneumonia, the court's never heard about Pseudomonas. So with that in mind, it's fairly unlikely that they would have heard of this other maltophilia condition, given that none of these other things, when they are discussed, they're dismissed, and a lot of the times they're not even discussed at all. So I just wanted to establish all of those things first and foremost before just doing a little bit of summing up of this part. So I just want to do a quick summing up of this section because it's quite complicated. The first thing is that all the information I've just mentioned now about sepsis, Pseudomonas, and the problems on the unit, that was all known already. It was barely referenced in court though, and in some cases it was not referenced at all. When it was referenced, it was largely dismissed by the primary prosecution witness, who continually told the court that all the babies were fine, they were all recovering, they didn't have any problems at all, then they just collapsed suddenly for no reason. And both Dr. Evans and Dr. Bohin have denied this, and they've said, "Oh, we didn't mislead the court." Whether or not they deliberately misled the court, I don't know. But did they give the court inaccurate information? Absolutely. That's undeniable now because of what we know about the infants and what we know of the picture surrounding the infants. And I will at some point go through, I did it briefly, but probably at some point I'll make a video going through the clinical picture of the infants, just so that it's clear. And then you'll see what was said about them in court. And it was almost always, oh, the infant was doing well, it was recovering, it was fine. Oh, then it just collapsed for no reason. There couldn't possibly be any conceivable reason for this other than the injection of air. So that's the first point. The second point is Dr. Evans consistently denied any significance of infection, even with regard to cases in which far more qualified experts have now cited infection as being critical. The third point is the original assertion regarding Stenotrophomonas maltophilia is that this was ventilated, as the lawyers put it, during the court process and ruled out by testing. Testing will be further addressed in the next section, but what we see with other well-documented infections is that they were either barely discussed or disregarded. And as I say, it's very important to note these infections, these conditions, they cannot be contested because they're in Thirlwall documents, they were known on the unit at the time. Indeed, sepsis is endemic on the unit quite clearly. It's just Dr. Evans said, oh, it doesn't matter, or denied it, or it wasn't even mentioned in some cases. Pseudomonas not even been ventilated, to use their word, in the court case. So they're making the assumption, they're making the assertion that this condition here has been ruled out by testing and ventilated during the court process. Well, it hasn't been ventilated during the court process. I've already touched upon whether it's been ruled out by testing. I see no significant evidence for this. In fact, all the evidence points to the opposite. But in this next section, we're going to examine that in further depth. So in this next section, I want to discuss testing at the hospital and the evidence that we know from the court case regarding testing at the hospital. I want to begin by discussing genetic testing, because this is something that was highlighted to me during one of the many interviews that I've conducted. And it was essentially pointed out to me that genetic testing hadn't really been conducted at the Countess of Chester. So I wanted to just go over the court case briefly and demonstrate what was said about genetics in court. So there was one genetic test done in relation to child F, which was for the presence of Down syndrome that you can see here. This was discussed in court. And then Ben Myers asked if a further microarray genetics test can be conducted to show for further potential genetic disorders. Dr. Beach, speaking in court, confirmed that this is the case. Essentially, they did one genetic test for one thing. Now, you'll see the significance of that shortly as I move on this subject. Further discussion here of a scan that was done in relation to child C that showed there were no genetic problems. If you get a geneticist, if I was to get one on here to discuss this, you would find out quite quickly that a scan is not really enough. It doesn't rule out genetic problems. It's information that can be used to some extent, but it's hardly viable to rule out genetic problems completely. And then there's a reference here to child P in private eye, where the parents were referred to discuss potential genetic causes of sudden unexpected postnatal collapse. So essentially, the hospital didn't do anything. They didn't conduct any genetic tests. They referred the family of child P to do that. Whether they ever did it or not, we don't know. But we know at the time, it didn't come in court for sure. It seems very unlikely that these tests were done, but even if they were done, they weren't done. The results haven't been revealed, and they weren't done by the hospital, that's for sure. I just finally want to reference this moment. This is from the Chester Standard Reporting, where Dr. Bohin says in cross-examination that she did not know of any genetic condition that would cause a collapse and death within 24 hours of birth. Now, let's be generous and say that she's not a geneticist and she cannot make... she's saying she does not know of any. The problem is that the jury can read that as saying no condition exists, whereas what she should actually say is, I don't know anything about genetics, therefore my opinion isn't of any value. But this is the only other reference. There are no further references. I'm just going to show you one more in the actual court transcripts shortly. So this is the court transcript for child A and child B, and you can see here some questioning of Dr. Evans regarding genetic conditions. So he says here, tell us about the genetic testing in this case, or metabolic testing. Genetic conditions causing air embolus, okay. So I assume that he's deliberately misunderstanding the question. It's hard to say. No, you asked me, I'm answering your question, has there been genetic metabolic testing in this case? As far as I know, no. And I happen to know for a fact that genetic testing has not been done on these infants. They go on to discuss it a bit further. I'm unaware of any genetic condition that would lead to blah, blah, blah. So it's important to keep in mind a medical condition that is currently known but may be currently unidentified. It happens, yes. Sometimes you have to keep in mind it may be due to a medical condition that is currently unknown. Sometimes, well, these are hypotheticals, aren't they? Yes, they are. There may be a problem in care given that has played a part and that takes place. In the care that is given or treatment, yes, that's a possibility, and so on, and so it goes on. The point is that the hospital hasn't done any genetic testing. I happen to know this for a fact. I can't say how I know this, and unfortunately I can't include the reason that I know this in the book because there are legal reasons. behind for that. But it's pretty clear from the court case anyway that insufficient genetic testing was done, i.e. basically none. I haven't seen any evidence there was any genetic testing done apart from one genetic test for Down syndrome on child F. And I just don't think they did anything on any of the other cases. I'm now going to demonstrate to you why that is significant. So I've asked a question to ChatGPT here, roughly how many rare genetic conditions exist. There are over 7,000 rare genetic conditions identified so far. These conditions vary widely in severity, symptoms, and inheritance patterns. Many of them are extremely rare, affecting only a handful of people worldwide, while others, like cystic fibrosis or Duchenne muscular dystrophy, don't know if I pronounced that correctly, are more well known. Since genetic research is advancing rapidly, new conditions are still being discovered, and classifications may change as we learn more about the human genome. So there's a couple of things to mention here. Firstly, as there are over 7,000 rare genetic conditions, and Dr. Bohin works in a small unit in Guernsey where probably very little occurs, it's very difficult to imagine that she knows about everything about all those 7,000 rare genetic conditions, considering that it requires an expert geneticist to be fully conversant with them, and even then, they probably may not know all of them inside out. She did, to be fair, say there are no genetic conditions that I know of, but I suppose she didn't mention the fact that she doesn't know anything about any of these rare genetic conditions. The second thing to mention is that this sentence is significant, that new conditions are being discovered all the time. So I'll just read this out to you briefly, and then I'll further explain this. So I've asked roughly how many rare genetic conditions exist that we don't know about yet. Of course, that's a very difficult question to answer. So ChatGPT said it's impossible to give an exact number, but scientists estimate that there may be thousands of rare genetic conditions that remain undiscovered. Here's why. Known genetic disorders. There are currently over 7,000 known rare diseases, with many having a genetic basis. Undiagnosed conditions. Studies suggest up to 50% of patients with suspected genetic disorders remain undiagnosed despite advanced testing. Genomic dark matter. Large portions of the genome, including regulatory regions and non-coding DNA, remain poorly understood and could harbour undiscovered disease-causing mutations. New mutations. Many rare conditions arise from de novo mutations, new mutations not inherited from parents, meaning new disorders can emerge in each generation. Estimates suggest that several thousand rare genetic diseases may still be uncovered, but advances in whole genome sequencing and AI-driven analysis will likely reveal many in the coming decades. Now, the reason I'm particularly highlighting this, of course it's very important and interesting, is that I was told this by a geneticist. That's the only reason I know how to ask this question, because I don't know anything about genetics, of course. But I was told, firstly, there are thousands of rare genetic conditions, and then there are probably thousands more that we don't even know about yet. So, of course, you can't expect the court process to account for something that we don't know about yet, but there are thousands of rare genetic conditions. That's undeniable. It's also undeniable there was no genetic testing done in this case. So none of those potential causes have been eliminated. But the reason that I'm raising all this is it's the first indication of many, there are several to come, that the standard of testing at this hospital was not particularly great, and the standard of testing that has been inserted into the court case was also not particularly great. I want to remind you that the whole basis of this assertion in the Times newspaper and by the lawyers representing the Thirlwall families is that this condition, this initial pathogen related condition that we're discussing at the start of the video, has been ruled out via testing. But we'll see quite consistently across multiple areas that testing at this hospital was very poor, and testing that went into the court case was very poor. Before I go on to discuss this next example, I just want to mention briefly as well that there's evidence in court of blood tests not having been done, that this was explicitly discussed, and that there are documents in the Thirlwall inquiry indicating this as well. So I just want to mention that. I also want to show you this example. This is a Thirlwall document, INQ00004330, page 1 of handwritten meeting notes, dated 20th of July 2016. This was written by Dr. Stephen Breary, who I'm sure you're familiar with. He was the person primarily responsible for fingering Lucy Letby in the first place, who worked in the Council of Chester as a paediatrician. This is the document itself. I'm going to try to make this as clear as possible. So I just want you to look at this section here, where I'm circling the mouse cursor. It says feeding bags for analysis. Emails from Stephen Brary and I can't read that name. Agreed, retain, do not send for analysis. Now, as far as we can see, this was highlighted by my brilliant researcher. As far as we can see, this means that they have retained the feeding bags for analysis. It surely must be the feeding bags associated with the insulin cases, and they have decided not to send them for analysis. I mean, it's plain that they have some feeding bags. We can't say definitively, I don't think. Maybe we can from the note as a whole. I mean, I find it very difficult to read this note, but we can say they've got feeding bags. You would think they have to be related to the insulin cases. They've agreed to retain them, and then they've said don't send them for analysis. There appears to be no conceivable reason for this. Now, if these were the feeding bags from the insulin case, if they sent them for analysis, this would have either completely torpedoed the prosecution case for the entire court case immediately, or it would have confirmed that they were deliberately spiked, which is considerably less likely. So this could have ended, if they'd have simply sent these bags for analysis, they'd come back clean. That's the end of the Lucy Letby being prosecuted, because the whole prosecution is so reliant on these feeding bags and on the insulin cases. So that would have been it. And I wouldn't be recording this video. We never would have heard the name of Lucy Letby. Probably in the future, there would have been another similar case because of the way that these cases are being investigated, which is something I've highlighted in my book. There's a nurse on remand in Birmingham now who I believe probably would have been charged by now, but they're probably waiting to see what happens with this case. I suspect it's very similar to the Letby case and to Colin Norris's case. And the reason that I say that is if they had concrete information, they would have charged her already. So they haven't charged her already. So I suspect it's going to be, oh, look, we got some strange readings and this nurse just happens to be on duty some of the time. But she hasn't been charged. I suspect she would have been charged if it wasn't for the Letby case. So if the Letby case hadn't happened, I'm sure this nurse in Birmingham would already be in the firing line. So that's another indication of the kind of poor level of testing that went on at this hospital. I just want to highlight as well that this was mentioned in Private Eye in this paragraph here. This is the 5th article written by Dr. Philip Hammond. Most concerning, the doctors who long suspected Letby of murder and allegedly called her nurse death had a statutory duty to contact the coroner after every unexpected death and voice their concerns of deliberate harm, so that it was on record and a full forensic post-mortem, including definitive insulin testing, could be done. The parents would have been informed at this early stage of what was happening and why. Most crucially, it could have diagnosed or excluded murder much earlier. Why did this not happen? Why indeed? I don't think Dr. Hammond will know about this document because it's a very obscure one from the Thirlwall inquiry that I'm extremely fortunate this was highlighted to me. But they had the bags on hand, it seems, and they simply didn't do the testing. And then after the fact, when testing can't be done, there's then been some inadequate immunoassay testing done that's been roundly criticised by anyone that knows anything about the subject, and then they fingered Letby on this basis. Obviously, at some point, I'll get into discussing the insulin tests and the insulin cases in more depth, but it's a critical component of the overall picture regarding testing on the unit and the tests that kind of appeared in the court case, which were, I think it would be generous to describe them as deeply inadequate. Issue I want to highlight was the insulin testing that was done in the court case. Again, I'm sure many people watching this video are somewhat aware of this already, but I just want to go over this in a little bit of depth. So the immunoassay test that has been used has been heavily criticised by people that are experts on insulin, several people now. It's mentioned here in this Substack, it's written by Kate Nichols, with some other people contributing, that the insulin assay test used is not designed to discover or measure the presence of injected insulin. Indeed, the lab where the tests were carried out states clearly on its website that its insulin assay tests are not designed to measure exogenous insulin, which would require a more precise mass spectrometry, which we mentioned earlier. test at an entirely different lab, which at the time was in Guildford. I believe you now actually have to send them overseas because the lab in Guildford doesn't exist or can't process this kind of test any longer, but at the time it was Guildford. This mass spectrometry test was not carried out. So there's just the instructions from the actual test here. Please note that the insulin assay performed at RLUH is not suitable for the investigation of factitious hypoglycemia. If exogenous insulin administration is suspected as the cause of hypoglycemia, please inform the laboratory so that the sample can be referred externally for analysis. And then you see some comments here regarding child F. The insulin reading was extremely high, which Dr. Ismail, this is Dr. Adel Ismail, said should have set alarm bells ringing and led to retesting. A note on baby F's test slip also advised that the sample should be sent to the lab at Guildford for follow-up testing if administered insulin was suspected. Without confirming the integrity of the results, then you are entering into the land of guessing, added Dr. Ismail. There are many others that have expressed doubts, concerns, that have been critical, etc. I just wanted to highlight that particular comment because it particularly talks about this Guildford laboratory. This is a comment. This is the witness statement of Heather Marie Wilshaw-Jones from the Thirlwall inquiry, who worked in the laboratory that was involved with the insulin testing. And she stated, on the 12th of August 2015, I received and communicated results in relation to child F, as per other documents from the Thirlwall inquiry. The results show a low C-peptide and high insulin. This is difficult to interpret without a corresponding glucose level. In another document from the Thirlwall inquiry, I can see that I added a comment stating, exogenous suggests send sample to Guildford for exogenous insulin. This meant that I was querying whether exogenous insulin had been given due to the pattern of C-peptide and insulin results, i.e. low C-peptide and high insulin. Exogenous insulin is insulin not produced by the body. At the time, the insulin assay at Liverpool was not able to detect exogenous insulin, so a sample would need to be sent to another laboratory with the capability to do this. This is another statement from the Thirlwall inquiry from Sarah Louise Davies, who, let's just confirm what she did. She was also involved in the laboratory testing of insulin at Liverpool Clinical Laboratories in relation to these children. I documented that these results were communicated to Shirley Bowles, but did not record what she said in response. There was a requirement in our laboratory for all investigations for suspected exogenous insulin administration to be sent to Guildford, but there was no indication that this was suspected clinically from the clinical details on the sample we received or the telephone log of the conversation. No assessment of insulin or C-peptide assay interference was performed in our laboratory, so it's just her confirming that the follow-up tests were never done. Now, again, the first thing to note about this is it's another indication of the poor level of testing that was done at this hospital and that in relation to these cases and in relation to things that should have been tested. Secondly, the court heard something about this that is staggering and that frankly is barely believable. I'll just confirm firstly that Private Eye also mentioned this. Sarah Davies, a clinical scientist, explained how Dr. Counter-Chester failed to send blood tests to Guildford Laboratory to determine if any babies had been poisoned by insulin or not. And then she quotes what I've already quoted. So, frankly, without doing that, you just cannot confirm that it's exogenous insulin. Then it's nowhere near the standard of testing. There are lots of problems. These are well documented. I'm not going to go into them in this video because it's long enough as it is. But it's just really to indicate the standard of testing from the hospital and in this court case was very poor. So finally, I just want to go over some comments that were made in court by Dr. Anna Milan when cross-examined by lawyer, I've forgotten his name now, Asprey. Is it Philip Asprey, possibly? I couldn't say definitively that it was Philip Asprey, but it may very well be. So they're talking about sending samples to Guildford, and for some bizarre reason, Dr. Anna Milan claims that this was to determine a type of insulin rather than whether or not it was exogenous, which is completely untrue. And she specifically asked, just one matter arising, doctor, with regard to Guildford, so I understand it, would Guildford assist with whether it is exogenous or not? And she just said no. The results dictate that it's exogenous. And then there's some further discussion, and she's going, so really Guildford would have been deciding or assisting with exactly what type of exogenous insulin, yes, not whether it was exogenous or not, correct. Which is a bizarre statement that is just completely untrue, as we've already seen. So I mean that's a bit of an aside, but it just demonstrates the actual quality of information that went into this court case and the actual quality of science, which was quite consistently very poor as well. So this is another issue of Private Eye. It's part 7 of Dr. Philip Hammond's investigation, and here he discusses the insulin poisonings and the embolism cases, talking about consultants at the hospital, the Council of Chester generally. They didn't spot the alleged insulin poisonings, even though a consultant clinical scientist phoned the ward 9 minutes after analysing a grossly abnormal result to tell them what to do next. And they didn't tell the coroner they suspected deliberate harm after any of the unexpected deaths. As a result, definitive forensic tests for insulin poisoning and embolism were never done and cannot now be done. We will never have scientific proof of murder, and the arguments over Letby's innocence or guilt will continue. So this is just yet another indication that the hospital was very inadequate when it came to testing, and that these tests that were critical never appeared in the court case. So to return to Stenotrophomonas maltophilia, we've established that the allegation is that there'd already been tests done for this bacteria, and we've seen the actual quality of testing that occurred on this unit, and we've seen the fact there's no reference to testing. We've seen the fact there's no reference to genetic testing. And we've seen the fact they didn't do insulin tests properly. We've seen the fact that they had the feeding bags and they didn't bother testing them, etc., etc. I'm going to summarise all of this stuff at the end of the video, but in this final section, I just want to mention some specific things about Stenotrophomonas maltophilia. So I wanted to show you that understanding of this pathogen is evolving even now. So this is a scientific paper from May 2023 entitled Navigating the Enigmatic World of Emerging Multi-Drug Resistant Stenotrophomonas maltophilia. So that was only published 18 months ago, but as you'll see, there are more recent papers than this. This one was published a year earlier. This was genotypic or genotypic characterization of virulence genes and the effect of ascorbic acid on biofilm formation. As we mentioned earlier, biofilm, the kind of thing you'd see in sinks, can be very fertile for these type of pathogens, particularly Pseudomonas, but also this one as well. This is an earlier article from 2019, but bear in mind this was still published well after Dr. Evans began his case note review. I'll come back to the subject of Dr. Evans again in a second, but I'll just briefly mention this is about AHL degrading strains isolated from marine invertebrates. Microbiota attenuate the virulence of Pectobacterium carotovarum and Vibrio coralliticus, possibly. It's very rare in the English language you get double L and double I, so how you pronounce that, I don't know. Coralliticus, possibly. As you can see, that's a complicated scientific paper that was published in February 2019. I'm fairly doubtful that Dr. Evans would know anything about that. It's interesting, it's about marine biology, so I haven't read this paper. I doubt I'd fully understand if I did read it. But, you know, it's fairly recent and is still contributing to the evolution of understanding of this pathogen. There's one here from September 2023, Stenotrophomonas maltophilia in a people with cystic fibrosis, a systematic review of prevalence, risk factors and management. That would probably be less relevant, given that I don't think there's any suggestion of cystic fibrosis in any of the infants, but nevertheless it was published very recently. Unraveling the complexity of Stenotrophomonas maltophilia, a comprehensive review of current knowledge. This was published just months ago, just September 2024, not long before the panel convened. In fact, it might have been after the panel convened because they had the initial press conference in December 2024, so they may have taken this research into consideration for all I know. Clinical characteristics and genome epidemiology of Stenotrophomonas maltophilia in Japan. Again, a very recent publication in June 2024. And then finally, Stenotrophomonas multifilia isolated from the gut symbiotic community of the plastic-eating Tenebrio molitor. Very interesting, I'm sure. Published again April 2024. So the point is that the picture related to this pathogen that's already extremely complicated and requires specialised information, no doubt, to understand, is constantly evolving. So it's quite possible, and I would say even probable, that current understanding is being invested into this application for Lucy Letby from these world-class experts who have all these very prestigious positions. Now, with the greatest of respect, Dr. Evans, who hasn't worked in hospital for 17 years now, who was retired at the time that he began this case note review and had been retired for over a decade, there's no evidence they ever looked at any of this stuff anyway. There's no evidence they ever searched for it, let alone did any testing. But the idea that he would have identified, oh, this will be due to a Stenotrophomonas maltophilia infection, is laughable. There's absolutely no chance. And I just wanted to make that crystal clear and show how complex the scientific picture is for him. I mean, even with an embolism, he basically just Google searched it, found one paper and said, oh, well, this will do, this is close enough. And then obviously Dr. Xu Li has come out and said, well, he's completely misused it. The guy knows nothing, basically. So the chance of knowing anything about this, just because he's worked on a paediatric unit in Swansea like 18 years ago, is extremely, extremely slim. And you'd need to see very specific indication in the court case that there had been testing in relation to this pathogen. And as we've established, that simply doesn't exist. So the last thing I'd like to reference in this case is child G. Now, I'm not going to go over all the details here. I'll do this in a future video. But child G, the panel has confirmed, was suffering with enterovirus. Now, the interesting thing about this is it doesn't appear anywhere in the court case. You cannot find any reference to it. You cannot find any reference, certainly, to any testing of it, apart from this one post, which states, and obviously you could, I've anonymised this person, obviously you could identify this person online. Please don't send them any messages or anything, because that's not fair, and I'd like us to conduct ourselves in the right fashion, unlike people on the other side. So apparently, according to the RCPCH report, they didn't test fluids nor save any tissue or serums post-mortem. The Alder Hay pathology lab had no enterovirus or parvovirus test to perform post-mortem. That might be parvovirus. One set of twins was born to a mother with antiphospholipid syndrome. Having antiphospholipid antibodies plus viral infection increases the risk of thromboembolic events. Interesting, the stillbirth rate was also very high the year of excess deaths. Enterovirus infection is also linked to type 1 diabetes and the introduction of autoantibodies to cells in the pancreas. Neither baby had follow-up tests to ascertain if they had problems with insulin production. And this person goes on to say the hospital has screwed this case by not testing properly. And again, this is yet another example of poor testing, inadequate testing, no testing being done, and nothing related to the testing appearing in court because it never happened in the first place. It's important to note that the panel has now mentioned all these things. They've mentioned enterovirus, they've mentioned antiphospholipid antibodies, they've mentioned thromboembolism, and enterovirus cannot be ruled out because they haven't done the tests. Just as I'm absolutely certain they haven't done the tests for the subject of this video either. So that's a very interesting aspect of this as well, that obviously, as we see, the lawyers are not alleging that testing had been done for the enterovirus because they probably know 100% that it hasn't been done. So why they're asserting it in relation to this case, child I really don't know. But I think we've established in this video that it hasn't been done and that their assertion is ultimately groundless and baseless. So what I'm going to do now is sum up this video because I realise it's complex, I realise it's much longer than was intended, but it's necessary to go into all these details to show that this claim from the Times article and also the Thirlwall lawyers is just really without foundation. So I'm going to conclude this video by summarising the points that have been made. The first one is simply that eliminating the presence of Stenotrophomonas maltophilia requires very specific testing, and it is extremely specific. It's important to mention as well that it requires follow-up testing to initial blood test, otherwise you haven't eliminated it. There is no reference anywhere in the court case or anywhere online to this specific form of testing. It is therefore doubtful that the testing was done, considering the repeated pattern of failed testing by the Countess of Chester that is palpable elsewhere. We've gone over this fairly recently, so we've seen failings of insulin testing, basic blood tests haven't been done, no genetic testing, etc., etc. Indeed, it is quite possible that no testing was done at all. I would say it's likely, in fact, but let's be generous and say it's possible, as such issues were repeatedly skipped over in court, and it seems that this was never acceptably confirmed in court. Even in the case of this infant, which is child I, just to remind you, the mother was critical of the Countess of Chester for failing to perform tests related to necrotizing enterocolitis, although that didn't prevent Evans and Bohin from ruling it out despite symptoms being present. We know that Pseudomonas was circulating on the unit. We also know that this was completely discounted in court. So it wasn't mentioned at all in the court case, and they knew damn well there's Pseudomonas on the unit. And yet we just didn't hear any discussion of this in court whatsoever. We also know that sepsis was endemic on the unit, and this has been largely discounted in court and completely dismissed by Dr. Dowie Evans. So, unlike Pseudomonas, where there was some reference to it in the Thirlwall documents, there is continual reference to sepsis in the Thirlwall documents. It's been downplayed in the public process, of course. And yet, Dr. Evans has just said, oh, sepsis is irrelevant. It's irrelevant. So that indicates what has occurred in court with regard to infection. Furthermore, we know that enterovirus, now cited in the case of child G, was neither referenced in court nor tested for, and this was referenced online 3 years ago. And of course, this is now deemed critical in the case of child G, cannot be eliminated, cannot be ruled out because there's no testing done at all. The links between Pseudomonas and sepsis are well established, so it is not surprising that the unit experienced problems with infection, which could be described as endemic problems. It is also known that such infections are, at best, extremely dangerous for neonates and vulnerable infants. It is therefore highly doubtful that the presence of Stenotrophomonas maltophilia has been meaningfully eliminated, and there is certainly no explicit evidence of this. In fact, all the evidence points to the opposite conclusion, that there wasn't any testing done at all, and even if there was any testing done, it was deeply inadequate. Certainly, I think you can say with absolute confidence there was no specific testing done for this pathogen. I think that's pretty much undeniable from the evidence that was presented in this video. It is instead likely that lawyers have cited the court-stated conclusions of Dr. Evans regarding infection in this case. I should emphasise as well, these are generic statements just related to infection. He hasn't specifically referenced this pathogen. He probably doesn't even know that it exists. It should be noted that Dr. Evans ruled out infection in infants where there is undeniable evidence of infection. In fact, he ruled out any and all factors except the supposed malignant behaviour of Lucy Letby. He didn't even know about sewage on the unit, so I assume he fell asleep when this was discussed in court. It is therefore highly likely that the expert panel is aware of this information and has accounted for it in the report, which totals 30,000 words. I think we can say very confidently that if there had been the specific testing that is required for this pathogen, and that had been noted in court documents, and it was part of the public record, they would never be making this diagnosis. Finally, I'd just like to make a couple of corrections from my previous video, because I am going to be correcting errors that I make, unlike certain other YouTubers. So I just wanted to mention that I stated that Child D was not a very premature baby. Everything else that I said about Child D was correct, but this wasn't true. Probably because I hastily put together 12 infants off the top of my head in about 5 minutes, which I probably shouldn't have done, but it was a long video and I wanted to get it finished at that point. I should also have emphasised that the hyaline membranes that were indicative of acute lung injury were present in this infant. And the other thing I did mention is very important as well, which is that this isn't a correction, it's just an addition really. Dr. Margarides never looked at the clinical notes. He just relied on the statements of Dr. Evans. He said here, Dr. Margarides agreed that in all of the cases, he had relied upon expert reports from Dr. Dowie Evans, Dr. Sandy Bowen, and other clinicians. There weren't any other clinicians that provided expert reports really, or not of any significance. So that's really significant, and I would like to do a full video on that at some point. I have many ideas of things that I could cover, and that's one of them. So that's the end of this video. I just wanted to give a quick shout out to Mark Mays and Jabe. I think his video, I forgot the name of his channel, but I think it's just Jabe. Just for mentioning my video in their comments. I'm sure everyone knows Mark, and a lot of people will know Jabe as well. You should definitely check out their channels. I've been keeping a low profile because I've been researching and writing my book, and I'm not really a social media person generally, so I haven't had an online profile at all. So I'm really grateful for them for doing that, and you should definitely check out their exceptional work as well. So that's the end of the video. It wasn't supposed to be this long. I will make another video soon. Hopefully it won't be this long. We're going to be really busy over the next couple of weeks or next few weeks because I'm travelling to London and travelling to Manchester to conduct some interviews. I've got several meetings, and I've actually completed writing the book. I completed it a couple of days ago, but unfortunately there'll be yet another edit that needs to be ongoing because there's various things that need to be done. And also I will need to incorporate these interviews. But yeah, so I'm really grateful for the traction the first video got. I didn't expect that much. It was very much appreciated. And the last thing I would say is if you have any comments, queries, questions, or particularly corrections, please let me know, because I'm compiling these as a layperson. I'm not a medic. I have no medical qualifications. And it does involve me understanding some very complex information, which is not entirely beyond me, but it would be surprising if I didn't make the odd mistake. And I want to be committed to correcting any mistakes that I do make. So thank you very much for watching, and thanks again for the support. It's very much appreciated.